Thanks for joining us. Today, we're going to be going over what happened today with our injunction in Victoria regarding Monash Health, which has implications, I guess, for publicly employed nurses in Victoria. And that's what our focus will be on today. And we'll go through what happened, where we're going from here, and we're going to answer any of your questions that you have. So people saying, is this just for nurses? It's more targeted towards those people who are employed by the public health hospital health services in Victoria. So, but yes, mostly nurses. Just from the top, you may have seen there was a Herald Sun article out today about this. We didn't get the result we wanted, but there is a backup plan. It was heartbreaking, to be honest, given the amount of work and the submissions that particularly the guys on the other end of this call, Miles, etc., they put in was astronomical and really elegant, sophisticated legal arguments. And funnily enough, I think the results of today, although we weren't successful with the injunction, has put us in better stead for the trial. But Miles, I will throw to you perhaps because you may be able to say things without getting yourself into trouble better than I can.
Good afternoon, everyone, and thank you. I haven't had the benefit of seeing the news article, but today was what's known as an interim injunction. It was to stop a process where you were on a conveyor belt. So this meeting is designed for anyone who is a public sector Victorian health employee, focusing on there's nurses, there's midwives, there's clerical people and maintenance people, in all of the various health services that exist. Now, with the cause of action was against Monash. That's because Monash was taking the most aggressive stance of all. However, the advice today covers everything. So the federal court has only just decided not to grant an interim injunction. Your union undertook, by the way, that in the event that the main trial, which is still to come, was to lose, that they would cover Monash's costs. So they put their money where their mouth is yet again, this time to the tune of $290,000 that they were prepared to secure for your win. And I'm incredibly proud to be working for an organisation with the team. I'm not sure if there's a video on here, but if you can see the team here, they're all at the table. If you can't, I don't have an imaginary bunch of people around me. There are about 10 people at the table, all who works very closely with the various unions at Red Union. And I say that because what came out to defeat the injunction today was a concept that it wasn't in their mind that all of your exercising of your rights. The exercising of your rights, they say, because they made decisions between 5 and 11 of October, that all of your activity was entirely irrelevant for their decision making. And in doing so, the chief executive of Monash has done an affidavit, which in essence says that you're on a pathway. And that pathway was, if we were to make an analogy, was a lock in a canal. There was only going one way, and it was entirely in your employer's hand. And despite your efforts to communicate, they weren't going to do it. And because they had already made up their mind, then there's nothing to see here. So in other words, an employer has agreed to run roughshod over your enterprise agreement rights. Your enterprise agreement rights included Section 99 for very specific consultation with relation to risk assessments, those same risk assessments that the employers have said they don't need to give you. And also that they can only come to a finding under the enterprise agreement after they've had a reasonable opportunity to hear from you. And curiously, in the case of Monash, on the people and culture performance and behaviour policy, that if they're going to call it serious misconduct, it is only in the most quote unquote extreme times. And the EBA, and I hope someone from Monash is listening, and hello if you are, defines serious misconduct to be both deliberate and willful. As a consequence of deliberate and willful, when you're asking for your exercising of your rights, what the courts found today, which is not unusual, is that you don't need to have an interim injunction because it's okay. Monash has put submissions in that they can just fire you and pay you compensation later and your life won't be turned upside down. And when you sue in the court process, the first process is the primary remedy is also cash. And as a consequence of that, that cash is where that must go. What the court said is, as always, the primary remedy for bad deeds of somebody else's that you go to trial and you get cash for it. You don't get interim relief in the form of an injunction, which is to stop behaviour. So even though your employer went on a course of conduct to stop you exercising workplace rights beforehand, and we say then during this process that's okay, they might have to pay you compensation later. And they were kind enough to put a submission from their silks to that effect to the federal court. So they're on record. And then they asked the court to confirm that as of today, they would have rights to sack you because they made an undertaking for the Monash nurses not to fire you during that time. I say all that because it's quite an extraordinary situation where an employer would admit to running completely contrary to your interests, completely contrary to an enterprise agreement, completely contrary to a disciplinary policy, and that disciplinary policy is enlivened under the enterprise agreement. And while it was a scratchy line, we understand they also made a concession that they didn't consult under your occupational health and safety laws. So all that's happened today is that your employer has locked in the most brutalised of versions of events, which is their right. The boss himself filed an affidavit, and I would, which has been stamped by the federal court and submitted as evidence and accepted as evidence, where I wanted to read some of the more salient bits where Andrew Strip told the court that he puts you on this pathway. And at paragraph 27, this path of steps to ensure compliance with the CHO directions and address the employment situation of unvaccinated employees and those that refuse it was decided upon on the 11th of October. And that if you didn't, then it would be a breach of discipline having regard for 28A. The drama with that, of course, is there is a disciplinary policy enlivened by your enterprise agreement and you'd all run an industrial dispute. And so as a result of that, your union has today been very busy in alerting your employee to the stage 1 dispute under the enterprise agreement, which does have a status quo clause. Similarly, those nurses that have been represented by worker law have those instructions as well, and they have also been applied. Why I say that is that more action has happened and collective industrial action within the meaning of your enterprise agreement has been launched today at most of the major health services and Monash, including those that didn't get their interim injunction. We say that the laws are absolutely clear, that your enterprise agreement directly contemplates all of those issues. That is the issues of discipline, the issues arising with relation to consultation, the issues arising to what is misconduct and its definition, and finally, only after a finding of misconduct, which interestingly allows for the reasonable chance for your union to be involved, then only then can they make a finding, and then only after making a finding can they put it to you. So we say those show cause processes that you're all going through and those investigations are entirely premature and are directly inconsistent with Section 99 of their own enterprise agreement, amongst others. Okay, I'm going to skip. So why we say that performance and behaviour policy is so important is under the enterprise agreement, it defines misconduct very specifically, and it enlivens, in the case of Monash, a policy. And critically important, it says that, and I'll read it out to you. This procedure must be read in conjunction with any applicable industrial instrument. For example, an award or contract or enterprise agreement. Now, what that means is it does enliven the enterprise agreement. And in case there's any doubt, at paragraph 6 of the Chief Executive's affidavit, it made that point clear. So it's a case of the nurses and midwives, there can be no doubt, and that of course flows to other employees. So while today was a bit of a blow with relation to an interim injunction, we have immediately commenced on those same nurses and for all other health workers in Victoria who have been exposed to this, an immediate industrial activity, so there can be no doubt with your employer. And there have been letters going out to Peninsula, to Northern, to Eastern, to Western. So if you are in any of those health services and you are facing any discipline at all, or anything that is not allowing you to consult after that Direction 51 letter, then it is critical that you alert your union immediately so they can advance your interest. And by that, we mean today, we understand that we have approached every single person that is facing a show cause process right now. The award for nurses and midwives also allows for collective action. And so we have alerted the employer to collective action. And that if they were to then take any steps now, it would be, again, courageous. But I need to be clear. Your employer has made it very clear that they have looked at one health order. They haven't looked at Workplace Direction 51. They haven't looked at your EBA. They've refused to engage with the EBA clauses. And that's all subject of a separate trial coming up. So none of these issues are over. Our senior counsel, for the purpose of convening today, said that wasn't pressing the enterprise agreement issues because the point was your employer had acknowledged straight out that it had not done its consultation with relation to safety. Upon not doing the consultation with safety, then the prima facie case has been met. Why I'm giving you those words are that the court found that the only reason the injunction would not be appropriate, or the primary reason the injunction wouldn't be appropriate is that there are other ways that you could be compensated if you're fired. We say that it's a temporary order. There are other issues, and now there is a series of industrial matters that have been raised, and all health employers or health service employers are put on notice. So, Jack, I hope that covers in broad strokes what's taken place, but I'm happy to field specific questions.
Yeah, thank you, Miles. And again, the sleepless nights, long hours, etc., that Miles and his team have done have been extraordinary, and these guys are just absolute legends. But I guess just the one point I want to note, and this is probably me rehashing what Miles has said, but just in even more layman's terms, perhaps. But that just because we don't have the injunction today, it was a thing of beauty to see Miles' genius, which I didn't even know, this ready to pivot immediately and launch an industrial dispute, which could have the same impact of protecting your jobs, just albeit slightly less force of the federal court and an order from a judge. But because there's now an industrial dispute on foot, we can still try and hold the employers to account and get them to follow that EB process. So take my hat off to Miles. It blew me down. But someone's been mentioning, where do we go if where does all this end up if Dan Andrews gets his bill through? I'll be perfectly frank with you. I think it puts us in a very poor position. I think it gives him pretty much unmitigated power to make whatever direction he deems. So, geez, I know it's probably not what you want to hear, but I'd be looking to get out of Victoria, to be honest. But my understanding is I saw an article in the Australian, and this isn't guaranteed, but perhaps to give you some hope, I saw an article in the Australian saying something like the Assistant Attorney General, Amanda Stoker, had said that the government could, if it wanted to, essentially ride roughshod over or intervene in what Dan Andrews is trying to do. I think using some sort of constitutional power, maybe the external affairs power, don't hold me to that, but said that she could do that. So perhaps one of our next steps in Victoria is that we should be inviting the federal government to intervene as much as we possibly can. And perhaps that needs to be wider than just nurses in Victoria. Perhaps that needs to be a lot of people in Victoria asking the federal government to do that. But that's all I'll say on that matter. Sophia, maybe do you want to read out some of the more pertinent questions, and Miles can answer them. Oh, when is the full hearing scheduled for, Miles? When's the trial?
So there's an administrative listing that will be called upon in the next couple of days. So today was just an urgent one to try and get a court order to stop mass sacking starting from tonight, from 4:30 today Victorian time, and so we've now got to. It's got to be scheduled, and that we understand might be the next couple of days, but we haven't got a. It hasn't been scheduled as of right now.
There's a lot of people being terminated in Western Health, even people who, terminated while on sick leave, people terminated while on sick leave whilst they had COVID from Western Health. I guess what they just need to reach out to us, Miles, and we will.
If you follow those processes, right, there is no rational way. If their answer is that my chief executive said I could do it and it was a pattern, and that it was, well, obviously we have to assess each case on its own merits, but please, we are bracing ourselves for potentially thousands of dismissal or general protections matters. If the employers are running such roughshod over the law, then it's not going to be just ignored. Dismissals claims will be made. The federal court allows for reinstatements to occur. And it's also important to understand the concept of reasonable management action. Now, if you're getting sick and stressed as a result of what you're seeing in recent days, not the direction to take the jab, but your employer, by all accounts, behaving unlawfully, by setting a path, in their own words, to unlawfully deny the most basic of enterprise agreement rights. They voted on the enterprise agreement. They said yes. They follow it. And if they don't, that even if it's not a general protections claim, it's still a contravention of Section 50 of the Fair Work Act, bringing with it heavy penalties. General protections claims, of course, can be brought in your name by your union as well, meaning that we can do multiple actions on behalf of multiple members. We've done that here in there are a number of matters already occurring. So please let us know. We have a 21-day limitation date on anyone, so it's critically important that you deal with it. Thereabouts in total between the team here at Supporter, Worker Law, and the Red Union Hub, there are about 30 people who have got tracking dates with meticulous detail and triaging them. The team that you're looking at there have been extraordinary, and there's a whole office out there outside of that burnt orange room that are also doing it. So we are triaging based on it. And bear in mind, each hospital service is its own legal employer, which means it's one application for Western Health, one application for Peninsula, one application for Eastern, etc. So, and if it is that this has burnt your relationship, that you've been dismissed and you now think that this gutter act that is occurring without so much as consultation means that you don't want to be reinstated, well, maybe that's something that we have to accept, that this chapter in your career needs to be compensated at the next stage, right? And so we've got to look after your own personal interests as well. And so sometimes it might be that an individual matter should be brought rather than a general protections claim brought on behalf of your industrial association. So it's really funny. I see Charlie McManus that refers to these guys as fake unions. She was reported in The Guardian as saying that risk assessments need to be done by employers only about 8 weeks ago, or even 6 weeks ago. And that's all these guys are doing. I just wonder where those other unions are. But anyway, that's probably a question that's not going to get us very far.
Geez, wouldn't this be a much better fight if we had unions on a unity ticket trying to protect workers' rights against bosses overriding enterprise agreements?
Well, the only way the bosses have had cover to run this level of monstrous conduct, and I mean that in a hyperbole way is because they knew that they had been given tacit permission from those legacy unions because they stood back and let this happen. And it's something that as I've said to repeatedly, I think we'll be talking about in years to come.
Where do we go from here with Monash Health? They have I'll ask these two questions. Where do we go from here with Monash Health? They have instructed me, I have till this Friday to respond. I know I said here I have a Zoom meeting with Monash Health nurse managers tomorrow at 9 a.m. for the final chop. Do I cancel the meeting and go ahead?
If you're in the Monash Health and you've had a meeting and you've run the industrial dispute, we say that should be dealt with in priority. And if the employer is forcing a meeting, then it is the sort of thing that we might bring an urgent application to the Fair Work Commission under the collective provisions of the EBA.
And separately to that, if you have a meeting at 9 a.m. tomorrow, perhaps you should get in touch with us urgently, because we are trying to assist people through those meetings. Miles, did you want to speak to if people are in a position where they are seriously stressed due to their employer's disregard to the enterprise agreement, the failure to follow the enterprise agreement and callous disregard of their rights? Is that something you want to speak to, or should we leave that for now?
No. So there's no two ways about it that a lawful order or a lawfully conducted discipline will nearly never give rise to a workers' compensation claim, for the obvious reason that a boss has a right to discipline a worker and a boss has a right to order a worker around. That's the secret to the name, right? It's entirely different though if you are being subject to a contravention of the Fair Work Act, whether that be a contravention of Section 50, Section 341, Section 343, Section 345 or 348, to name just a few. And that if that has caused you hurt, shock and distress, that may give rise to both claims under the Fair Work Act, but separately may in fact trigger a workers' compensation claim. You need to talk to your doctor about that. The lawful conduct of your employer is what's actually getting under your nose and causing you stress, and your doctor certifies that it's those causal factors, that is, that you haven't had a chance to be consulted with in accordance with occupational health and safety laws, in accordance with your EBA, that the disciplinary process is entirely inconsistent, and that when you've raised an industrial dispute, your boss has ignored it and tried to suspend you or otherwise discriminate against you and demanded you attend a meeting when you're too unwell to do so. Well, maybe you need to take that up with your general practitioner. If your general practitioner sees that is something that gives rise to a workers' compensation claim for unreasonable management action or unreasonable management action that has been taken in an unreasonable way, well, then maybe that's something that then does give rise to a work cover claim. Each one of those does turn on its own facts. But if this 2-week process where you have exercised multiple rights and you have been put on this conveyor belt has caused you distress, we'll take that up with your doctor. Your union will have all of the information to assist in any workers' compensation claim. You must do those in good faith and you must be telling the truth. But if these events, not the mandatory jab directions, not Direction 51, not comments about politics and changes of law, but if what has happened in the last 2 or so weeks has caused you harm, please go to your doctor, get the support you need first of all, but it also may give rise to a work cover claim.
Thanks, Miles. I think you've sort of addressed this in a roundabout way, and this question's come as a result of this newspaper article that you haven't had the luxury of reading it, Miles. But can you please clarify what Justice Snaden meant today when he said that your case is weak? So
the interim injunction question it's a fair question and one worth ventilating. The employer's position is that they made the decision between the 5th and the 11th of October and that everybody was then following orders of the chief executive. And as the issues raised were subsequent to that, that because the wheels were already in motion, it can't be adverse action within the meaning of section 341, which is in essence like a retribution clause where as a result of your actions, your boss has whacked you. What they're saying, no, we had this course of conduct already in play. The wheels were in motion. They politely called it a path, if you like, a 7-step path. And as a result of it, because it predated your complaints, by definition, your complaints cannot be the basis of adverse action. But of course, that's only one part of it. Now, given that that was the primary reason we brought the matter, the judge then looked at who were the decision makers and in essence said that, or intimated from the bench, His Honour said words about who's the operative and controlling mind. In other words, if the chief executive says it's so and directs everybody else to do it, well, they're going to go off and do it, and he's the architect. But that only contemplates section 341 of the Fair Work Act with relation to the exercising of the rights. Matters not before the court include section 343, which is the coercion into not exercising the rights, and section 345, which is the shameless misrepresentation of your workplace rights, all of which are yet to be ventilated in the court. And so, in essence, your employer has said, even if we broke every rule in the book, we thought about it between the 5th and the 11th of October, and so anything that happened after that can be unrelated. And being an interim injunction, it was turning on some fairly narrow issues, as in what have we got right in front of us now. The next stage is a statement of claim, where we will again have senior and junior counsel attend to those far more broader issues, attend to the issues of when the decision was actually made. Because when you look at the EBA, and again, I do hope someone from the health services on there, it requires a decision only after the information was made. So if chief executive has made that call somewhere between the 5th and the 11th of October, and then despite the EBA requiring consultation under section 99, and I think it's 13.5 with relation to discipline, it uses the words only after the response can a decision be made. If it's only after the response and you've responded after the wheels were put in motion between the 11th, the 5th and the 11th, even if the chief executive did set that path in motion, a decision had to be made after that fact. Now, if that means it didn't weigh into it, well, then your workplace rights have been enlivened at the moment that decision was made. So their argument, and I do hope they run that at trial, that we put our wheels in motion between the 5th and the 11th, and hang be God, nothing else can be done, no matter what you do, say, no matter how sick you are, you were in the departure lounge. Well, I think they should run that case. I would love them to. So it's a weak case to the extent that the decision happened prior, and that the courts would then say that even if there was unlawful activity that took place after that, you've got no redress. But of course, if we're running a case that is on retribution for your workplace rights, that is that you exercise them after the 11th of October, so therefore it can't be retribution, well, that just kills section 341, but it also at the same time enlivens section 343 and 345, amongst a range of ones, including section 50, all which bring heavy penalties. And I would put them on notice that that could be, in fact, a serious contravention, which is a far more significant matter. But I'm the lowest person in the legal food chain here. I'm only a lowly industrial advocate. Senior and junior counsel will make those calls. But for everyday nurses, clerical staff, midwives that are hearing this, it will only be a weak case to the extent that any decisions made between the 5th and the 11th allow an employer to do whatever the hell they want, irrespective of their legal obligations subsequent to it. And I look forward to that argument. Their senior counsel, their Queen's Counsel that has represented them, is one of the most impressive legal minds in the country with employment law. Reading his documents, they are immaculate. They are some of the finest legal reasoning you will see. But the employer has said, They set the wheels in motion between the 5th and the 11th. There's nothing else that can be done. Well, we disagree.
Is this summary correct? Which I think it's slightly off, but feel free to correct. But is this summary correct? Monash will continue terminating employees because they feel they can compensate with cash later on if needed. Monash have admitted that they have not undertaken due diligence, OHS, risk assessments, etc. Based on this, Miles will start industrial dispute for compensation for people who have already been terminated, or possibly to keep some jobs for people who aren't terminated.
It's pretty close, except for industrial disputes are for existing workers. So no one's been fired from Monash, as I understand it. Though I do know there's a couple from Western and one of the regional hospitals. There's been a couple. Those ones will be then the subject of a general protection dismissal or an unfair dismissal claim, depending. Those ones that are still employed, if the employer again wants to disregard the enterprise agreement and it results in a dismissal, it's just again yet another one. Whether it is then it's because you exercise the right to an industrial dispute under 341, or the conduct coerced you into being able to exercise the right under 343, or they told you you didn't have the right under 345. I mean, I have a letter from one of the health services, very senior people, saying we don't have to give you the risk assessments. But that same health service signed up to clause 99 of the EBA, which says you do.
I think there was another health service that provided a half-page graph that was their risk assessment.
That was the great elimination triangle, where I would have been impressed if my niece did that in grade 5.
Literally. What do you do if your employer won't give accrued leave after termination?
Well, they've got a month to get their house in order, otherwise that's a contravention. Quite the Simpsons, that's a paddling.
Is there a time limit that people need to be aware of for an action like that?
Unpaid wages, if your employer is holding wages from you after, the employer can't unlawfully deduct wages from you. If your employer is sacking you for serious misconduct when you haven't gone on a course of conduct and are holding off your notice period saying that they don't need to provide it because it's summary dismissal, well, that's a different beast altogether. But if your employer, the easiest rule of thumb is unless you're in a real estate type or other commission function that the commission was earned after you left, the absolute outer limit is a month after your employment ended. And then it's got contraventions, and there's multiple ones depending on what you're owed, but your boss can't hold off your entitlements, they're yours. And if the conduct has interfered with what otherwise would have been a long service leave entitlement, say you're at 4 years, 9 months, or and therefore you didn't get to your 5 years or 7, depending on which state you're in, that has a bearing. So, but of course, your employer zeal to remove you does not end their responsibilities. Indeed, it only, to quote the Carpenters, it's only just begun.
What about the government hiring people from UK and Canada? I might speak to that. I think it's absolutely outrageous. We've heard those rumours too, that they're trying to backfill because there aren't enough domestic vaccinated nurses to fill the spots now. They're happy to sack unvaccinated nurses and bring in foreign labour. I would have thought historically this would have been something that labour unions in this country would be on a unity ticket for, and that bringing in foreign workers to replace Aussie workers who are happy, ready, willing, capable to work would be outrage. I would be disappointed. I would be disappointed if other unions were to take the view that these unions, well, that these unvaccinated former members are no longer members of ours, so we're happy to trash workers' rights, throw them under the bus, and let's bring in some foreign workers who may end up joining our unions instead of those other pesky red unions. I I hope that isn't an accurate case appraisal. It may not be an accurate case appraisal, and I do hope that we are in unity together with the other labour unions, showing concern about hiring foreign workers to replace Aussie workers. It's certainly something that you'll hear far more about from us in the coming weeks. Don't you worry about that.
I can only echo that, and that brilliant, well-trained people, particularly in the case where it's a temporary order as well. Currently, it's only the 18th. That where's the fire to sack people? Make no mistake. To quote a fairly impressive barrister I've been dealing with lately, he used a phrase, collateral purpose. This is about getting people's heads to roll so that more people will be scared and roll up their sleeves. It's a way to communicate. Had they just had a chat, some of you would have already had your jab. It's very interesting for a city with that prides itself on its Charter of Human Rights. And I'll take no further. Hey, but Jack, I haven't had a chance to look at that Herald Sun article, and I'm in furious agreement with it. Can I just read a paragraph? In the ruling against the nurse, Justice Snowden said, the course that has been plotted because Monash Health has formed the view that the public health directions by which is bound don't permit it to do anything else. And so we are on a unity ticket. That's the evidence before the court. And we look forward to them saying later on as to why they don't permit to do anything else, considering the thousands of options that are available. But they've now locked in their position. They can't do anything else. They've admitted they've plotted the course, and the chief executive has referred to himself as the architect. So they've built this road. I look forward to now the next journey.
Can our workplaces not be held responsible for our mental health? I think that's Jane. I'd advise we are recording this. We will upload it in our telegrams and social media, etc. Go back. Miles did canvass this with potential work cover stuff if you are suffering health.
Worth revisiting that one though. The test for work cover is that as a rule, your mental health issues are excluded from any workers' compensation claims. However, if your employer goes on a course of conduct that it harms you, there might be two different options. If it's unreasonable management action, or in the alternative, management action that would otherwise be reasonable but has been executed in an unreasonable way, that may give rise to a claim for workers' compensation under your workers' compensation policy, and only your doctor can draw that nexus, and so your doctor would need to certify that. But if it is the case that you've been harmed in the course of your employment and you have been financially damaged, you cannot work, or you've otherwise experienced hurt, shock and distress, that there are powers for the federal court to redress that in the form of compensation for economic loss or for general damages. And so that's not for me to talk about as but my role is obviously far more at a ground level, but the NPAA's lawyers and barristers can assist you further with that.
If we got terminated with serious misconduct, is that going to affect our registration? If it did get raised with APRA, that's something we can help you out with as a union member.
If you have been sacked for serious misconduct and you have been following the good faith processes, one of the most likely options is the courts are going to be asked to make a declaration that it's not serious misconduct within the meaning of the definition of serious misconduct within the EBA. And I'm not telegraphing trial strategies here, that the concept of misconduct is clear, it's deliberate. But in the Monash's, in the Health Services, Nursing and Midwifery EBA, it goes one step further. It says willful and deliberate. Willful and deliberate. They have characterised a refusal. Either they're saying a refusal, and this is a cheap shot, by the way, a refusal to disclose your vaccination status. Watch out for that one, by the way. If your employer's asking, saying you're refusing to provide it, make sure you confirm that you are not vaccinated for the reasons they know. That's just a trick, and a cheap trick at that. And the second one, though, is that you're refusing to be vaccinated, which of course no one is. We've made a point of, since this whole process has started, if you are a no, not ever person, that you're never ever going to get a vaccine, no matter what, then there is no assistance that is available for you on the services that are being offered under this approach. This is about genuine consultation. Now, if your employer has then harmed you because of that. Your employer has broken you or in other ways prevented you being economically engaged because of that basic step not being followed. Well, that is something that you might be able to seek redress for in this forum or another.
Austin Health have now developed a COVID risk assessment for work areas, but it doesn't mention the vaccine. That's bizarre because you think that that's if they're going to implement a mandate on vaccination, then they would mention vaccination.
You're being a bit difficult there, Jack. Hospitals don't need to really do much in the area of safety and risk. I mean, it's not really an area they have to turn their mind to that often.
Yeah, and Georgina here, they don't need to do a risk assessment. That's not the case. Laughably not the case.
And by the way, the risk assessments are meant to be done in consultation with the worker. You know, you people, you pesky little commoners that are trouble themselves by delivering on those frontline services. You know, the whole concept of consultation, and the federal court has looked at this. It says that it can't be merely perfunctory, that you actually get to influence the outcome, even if you don't end up influencing the outcome, that you may, right? You know, we make lots of jokes here. This is a situation where you're dealing with an automaton, a robotic process that you can't influence in any way. And we now know, and I do like the term from His Honour about plotting, right? And so the chief executive whipped up his mustache, stroked his cat, and set us off on a little adventure where nothing else could happen, and a royal decree. Now, I do understand in Victoria, your parliamentarians do want to have all the rights in the world and get rid of that pesky human rights charter and make decisions that are, I think the bar associate down there referred to as close to royal decree. We say that that's not the case. And if you've got that risk assessment, by the way, at Austin, please pass it to us so that we can actually use that to consult.
Scroll down. Is Monash case still going to trial? Is it finished? No, it's still going to trial. Many of us have meetings these next few days. What should they do? They should get in touch with us via email or via live chat on the website. It would be even better. If you go to redunion.com.au and then click on your relevant union, and there's a live chat window there. It'll ask you some prompts and follow those prompts. Alternatively, I think Miles has said there may be some legal actions in the wings, particularly from Monash.
So I'll break it into the three categories. If you are at the investigation process, then you will be seeking more information, no doubt. If you have received a finding or a show cause, then that is not open to them based on at least policies consistent with that of the Monash's people and culture and performance policies. So for all of your hospitals, health services, they'll have they've got a couple of policies. The ones we need, the EBA refers to two, and again, putting our opponents on notice for those that are amongst us. Under the discipline, there are two policies. One is the performance discipline policy, and the second is the investigations policy for your employer. So your health service, the way the construction of the EBA works, should have that. Jump on your intranet. We need as many of those as we can get from the different health services, just to make sure they're different. If they are consistent with the Monash one, which we assume they are, but I'm sorry, I know a bunch of it, and thank you all for getting them in today. I just haven't been able to have a look at them all. They are read in concert with your enterprise agreement, and so we need to have that document for your health service to make sure those two things are there.
Will the industrial action include the private sector also? My understanding is that the private sector is sitting back and waiting and watching what's happening in the public sector first. But if I'm wrong on that, please get in touch with us.
You know, a couple of Red Cross has moved on a couple, as has Boeing as of today. So there are a couple of the ones, and I saw we've also got 4 members who are at St John of God, and we're moving on those as well. So those private hospitals that are a part of the Victorian environment, their EBAs are similar. Absolutely get in contact with us. The EBA terms, though, for each of those employers might be different, and your unions team have been incredibly diligent trying to draw those. And I say to the cameras on there, there's a team of 10 in our office as well that are dropping everything to ensure those EBA terms are complied with. And again, putting the employers on notice, you signed the affidavit to get those EBAs in before the Fair Work Commission, and you are going to be held account to them to the very final word. And if you don't, you do so at great risk, and any natural person involved in that can be named as an accessory in that. And it's not to be threatening. If you wish to not follow your lawful industrial instruments, bring on what comes next.
This is interesting. I got a letter from HR with the heading "Notice of Employee Representation Rights" after asking for a risk assessment. So,
no, that's wonderful. By the way, that NERR is that while all this is going on, your employer has commenced its next round of bargaining for these agreements because they expired at this late last year. What's funny about that is they want you to bargain on their agreement that they don't want to follow right now. So you absolutely, they're called a NERR, and they trick a process. And pursuant to section 176 of the Fair Work Act, you can appoint these wonderful people at Red Union, at your various unions, any natural person, any company, to be a bargaining agent. And if you are upset that the legacy unions have let you down, they get a standard seat at that table. They don't have to do anything. So despite them ignoring you, despite them leaving you to rot in this particular case, they then want to bargain for your rights and your interests, and they get a walk-up start. They don't even have to fill out a piece of paper, automatic seat at the table. But you can kick them out. You can actually just issue a document under 176 to say, sorry, you've let us down. We don't actually want you bargaining for our interests, because when the times got tough, you went and teamed up with the bosses to do nothing and allowed this disgraceful conduct to fester. And to do that is a single piece of paper. So if you've got a document called a NERR, a Notice of Employee Representational Rights, for the love of God, get them to Red Union immediately. If you want Red Union to be appointed to be in your corner, I can assure you the best and brightest that are available to us will be at that table to ensure your interests are protected when the times are tough.
Yeah, that's exactly right. Get that in, and we will start that process, and we are more than happy to commence bargaining, and see what these unions have to say at the bargaining table. No doubt they'll probably be pushing for you guys to be terminated even quicker, but let's see where it goes with the trial for the Monash case.
I'm sorry to interrupt, Jack. I can't make too loud a point of that. All of you, and again, I'm incredibly proud of the respective teams that have worked together on this one, and in very sleep-deprived circumstances. It really has been a symphony. But the only reason they've had to do it is nobody else did. So how dare they now get a seat at the table? Don't let them.
So what happens next after this industrial action letter that went out today?
Well, if they're true to form, they'll say that nothing to see here, in their best version of Colonel Clink. And so we will then need to take them to the Fair Work Commission and show that they have signed up to that EBA.
Yep. The work you guys are doing is really appreciated. Things are clear as mud right now. What actually happens next with Monash Health employees? There has been, the first stage of industrial action has been started, or industrial dispute rather.
Technically, a stage 1 dispute under the EBA, and we've also the EBA has a collective clause that if there's a common interest, we've raised that and we put them on notice. Importantly, with the common interest clause is once the employer is given an opportunity to treat it as a common interest clause, we don't then have to take steps, the additional steps. We could go straight to the Fair Work Commission as door number 2. So the team here have put very urgent communications out, asking them ensure that they are accepting it's a collective interest. And so we should know that tomorrow. And if they don't accept that it's a collective common interest, then we will file an F10, an urgent F10 with the Fair Work Commission.
So will they terminate us while this process is going through the court process? That the industrial stuff, and Miles talking about the dispute that we've just started is to try and stop that.
It does have a status quo clause. They should follow their procedures, but it hasn't really been so far a part of their DNA. So who knows?
Everyone that's been stood down, you still have the job but not being paid. Look, we're trying to work through this as quickly as possible. We're trying to keep people in jobs in the first instance. So where there are people going through show cause process, we're trying to halt that so that they can stay employed. And then, you know, eventually we will go back and try and make claims for unpaid wages for those that have been stood down. Those each case will turn individually on its merits, but for those people that stood down without pay because of your irregularity out of work and you were stood down simply for wanting to consult, then that is something we would look at as well. What is the outcome? What outcome are you hoping for at the end of this? Well, a number of things. One, consultation and a risk assessment, and there will be a number of things that come out of that. For instance, and this risk assessment is so pivotal. So if for instance, there are plenty of states where they're allowing exemptions for people who haven't haven't got the jab because, for instance, they may have an anaphylactic reaction to it and may kill them. So therefore, they're granted the exemption. Does the hospital service then send that person in to work in a COVID clinic? We don't know. They should risk assess that. If they're putting those people into less risky environments, perhaps not COVID clinics, perhaps not emergency rooms, perhaps, I don't know, the pediatric ward. Well, that should all come out in consultation. That should all be a part of the risk assessment process, you would think. And if they can do that for those that are getting exemptions, well, why can't they do that in the very beginning for everybody, particularly those that are waiting to see this risk assessment, waiting to consult with their employer before they make a decision to go get the jab. There's many other things that could come out. You know, as of the first, there's now rapid antigen testing. Perhaps there may be something that can be done with that to keep COVID out of controlled wards, and perhaps it could work in a controlled ward. There's a lot of things that could happen, and I dare say most of that will be fleshed out in the trial, and that's what Miles was saying before. When the employers now on the path saying there's absolutely nothing we can do, and we look forward to seeing them argue that point that there is absolutely nothing that they could do.
And it needs to stress, and I haven't checked any updates, but I understand the mandatory vaccination order only expires on the 18th of November in Victoria. And for example, the Victoria's even looking at removing, albeit at the moment on fairly gross laws, the orders will no longer be relevant because they won't be able to be issued by the Chief Health Officer. So who knows? These are temporary solutions at the moment. And so what we've got to look at is what's the variable. Maybe a month's long service leave, all of that will be resolved, but that's why you don't need to lose your job. Maybe the consultation, the one that I've heard probably more than any is that people are particularly affronted that a gun has been put to their head and their conduct has been said to be misconduct, and they're going to lose their job and not pay their mortgage. And that might be somehow causing them to resistant, a little bit vaccine hesitant. My understanding in a relationship, if you say to your partner, if you don't do X, I'll leave you, is an effective way to get what you want, or at least it might work once. And I certainly know with my staff, the best way to do it is, could you please get that document done or I'll fire you? That always really inspires them, you know, and they go, oh, there's nothing else I want to do right now more than do this document. So as well as just being stupid at a communication level, also it's highly counterproductive to the very cause.
I should have said that myself. What happens if you are casual with Monash Health followed all the steps from your union, but they refused to pick up any shifts and have blocked my shift match. Do we get compensation on wages lost?
There's certainly potential causes of action there too. You've now been harmed by your employer, either through the misrepresentation or other ones. We need to look at your individual cases, but there's a potential issue there that you could pursue as well. Yes, but we they do turn on their individual facts, of course.
Does the note add to mandatory vaccinations direction number 11 change anything? Section 6, this obligation does not apply to a person who is a worker if it is not reasonably practicable for the person to work at the person's ordinary place of business.
So obviously the group that we're talking about, but we're seeing that more and more with employers in the private sector where people can work from home. Everyone has been, as the first justice that heard this matter, Justice Roth, indicated, well, how does a nurse work from home? Obviously, there are some functions that are lend itself to being able to work from home, and they're very different risk profiles for someone who can control an environment. Jack touched on rapid antigen testing. Now, of course, if there's a public health order, that's one thing, but if there's not, which is they're temporary, well, then can you control the environment by controlling who comes in and out? And so it depends on your situation. And so there's a range of areas that it's not a one size fits all. And so, yeah.
Sorry, I thought just crossed my mind. We have been trying to get in touch with our Victorians, particularly in the space, not as urgent yet for our private, but for our certainly our public sector Victorians. We have sent an email and some text messages. If you send the text message, please go and read your email and find it and action that. We need to know through a form, not via an email, but through a form that we have sent you, what your role is at the hospital, because we now need to differentiate whether you are a nurse and you fall under the nursing industrial instruments, or whether you are a admin worker and you fall under a separate industrial instruments, and we separately need to know who your employer is so that we can send preemptive industrial dispute letters that Miles was talking about. We've already sent them off for those at Monash, and we're slowly working through those HHSs that we have data for our members on. But once you go and action those, we can make sure that a letter gets off for you. Regards to the bill that gets passed, is it likely the federal government will step in, and what other states will be working soon to move to if most other states are mandating the jabs to send out workers? I don't know about moving to other states. Queensland's not so bad if you want to come up here.
We might stick to the problems we can actually solve.
The federal government intervening, I think that is a live issue, and I think there should be some encouragement given to the federal government to intervene on that particular bill, because as I said, that article in the Australian today where the Assistant Attorney General, Amanda Stoker, said that the federal government could do that if they wanted to, seems to me like an invite that they would like some pushing in that direction to intervene. So I guess that just needs more Victorians to call for that as some action. So there's a lot of these questions either chat amongst yourselves, or they seem to be things that we have canvassed. Someone said, yeah, a lot of people in this group have no background in how the law works. So I guess the layman discussion is, Miles, are we going to win? We would be remiss of any.
Well, what does win look like? Haven't we? I mean, the employer is literally in a submission said, "Oh yeah, you can fire them and they can get compensation through other means. We don't even want to hit the pause button on that, right?" They say even if termination was a likely outcome, unlike almost all termination of employment reinstatement injunction cases, a subsequent reinstatement order or compensation if the applicant's successful trial is an adequate remedy. In other words, rather than just stopping and pausing and having a chat with their staff, if you take layman's terms for that, let's not stop and pause. Let's fire them and let them to go and sue us while outside the tent. So I think that the Victorian government's health services would do that. We've already lost, haven't we? And at a really core level, that a Labor government and that's meant to be about the worker with a human rights charter, that's the submissions they're making. Well, we've already lost. But have you got a very good fight ahead of you? Yes, there are very good prospects of success, particularly with the now that the employer, in the case of Monash, has locked in their position. Other employers each different health service has its own employer, and if it turns out that the relevant health department or the Victorian government more broadly has gone on a course of conduct, well, that's something for trial litigation. But is what's happening on the face of it appearing to contravene the Fair Work Act in multiple places and contravening the Victorian Human Rights Charter? Then absolutely. Courts are very, very reticent to get involved in the COVID discussions, lest they fear that they're fueling an anti-vaxxer type component. I'm very comfortable that this has been a very clear, fair industrial cause about consultation with a legitimate outcome being to consult as the end in itself. And so there are outstanding successes potentially in front, but of course no one can promise that, because that's why we have a free and fair court system. And even if your employer doesn't want to behave free and fairly, your unions do, and certainly our legal team does.
There's a question here, what about the boosters? Should we ask for a risk assessment prior to getting the booster? Yeah, I guess my advice is keep pressing for the risk assessment. I mean, it has to be done. It doesn't, yes, short answer to that. There's a lot of stuff here about other things, EBA, the industrial letter sent today, what to do. I think we're going to have a look at that. Holly's going to message Emily in our office. There's some people saying here that they've tried to reach out and contact us, and we haven't got back to you yet. I am so acutely aware of that as a problem, and it's not gonna lie, it's a significant stressor. We're trying everything that we can to get through that and try and help with this. It's like this is totally unprecedented. I hate that word since the pandemic started. It's totally unprecedented what employers are doing at the scale of what they're doing. And even if all of the unions in Australia were in lockstep on this issue, I think we would almost still struggle to get through the volume of work here. And we are but one union, but one team helping. There are many unions here, obviously. But we are small compared to the other guys. But I think we throw a pretty big punch for our size. Marcelo, what do we do when we've sent the request for risk assessment 6 times? You always get the same answer. We are not required to do a risk assessment. You follow the dispute resolution process in your enterprise agreement, which generally follows send it to your manager. If they don't give you a satisfactory response, send the same request to your line manager's manager and CC them in, and then again keep going up the chain. If they've asked you to send this request to some other email address ancillary to that, like a HR email or a people and culture email, do that as well, and keep going till you get to the top, essentially. And then
also, Jack, I'm sorry to jump in on that point. Make sure if you have you link your EBA that you understand is the one that's covered for your employer, whether that be a private or sector. If you're covered by an enterprise agreement, it's critically important because there's so many, get as many to us as possible, right? So, and including asking your boss about that. So if it's a private sector or if it's a public sector one, obviously we're on those. But it's important if there's any other causes of action contained in that enterprise agreement that you grab them.
I think that is pretty much everything in the chat so far. There may have been a couple that we missed along the way, but a lot of them too have been covered previously, and we would have to go over old ground. So there will be a recording of this posted. If you do have a question outstanding, I think that you will likely find an answer to it if you listen to it back. I will just include, there's one here from Megan Miles for Premier. I absolutely agree. Miles, will you be putting your hand up to become Premier of Victoria?
Listen, we got an office in Victoria, and I used to live there, and I've always loved Victoria. I'm not very much a fan of your government right now, but we're itching to come back down. So because I might get locked and stuck there at the moment, there might be a nice hotel at St Kilda I can camp out while we've got these lockdowns, huh?
Yeah. All right. Thank you very much, everyone, for coming along. We will put up this recorded meeting, yeah, I hope this is an incredibly stressful time for everybody. Joyce says, "What next?" Exclamation mark. So there is a lot of things on foot at the moment, Joyce. We have industrial disputes which have just been started, and a lot of the HHSs that will very likely get to the Fair Work Commission very soon.
And Jack, just sorry to interrupt, Joy, two things, right? The what next, if you've been in this video for the last hour and a half, I'm sorry, this might sound a little bit clip tone. You've heard what next. It's not fair on everyone for everyone then to just sort of throw these sort of almost hands in the air stuff where there are so many people working at it, and you've just had an hour and a half of people explaining the what's next. We do need to call time on some of this stuff. I appreciate it's stressful, but throwing those kind of things back and just going, what next after you've had so many people stop and pause is actually unfair, right? And I'm sorry to be as plain as that. Secondly, and sorry to jump into that one, Jack, is the unions, so the industrial disputes were actually started all the way back with those Workplace Direction 51 letters. Your employers just ignored them. We've doubled down and pushed them to start today. So yes, that we're doing more activity on them, but they are actually byproducts of being ignored in the past. Right, so and we are triaging in order of events. In other words, if you've got a show cause or you've got a discipline, we're about 3 days in front at the moment. So if you're in that one, you're getting the first lot of attention, and we are trying to shore up as many bases into next week. Hence why there's so many people at the table, right? So, but when every other place has dropped and left the ball for these guys to play with, and only these people, please be fair on time allocation. I'm sorry, I don't want to hector at you, right, but thousands of enterprise agreements, thousands of different employers, thousands of different work types, and where all these have been taken on in nearly every case as members with a pre-existing matter, and these guys have dropped everything. I sometimes feel, and maybe I'm just tired, that there's these we can't get into contact you type questions when there is so much going on. We're talking 5,000 emails sometimes in 3 days. Means we've got to also just know at the moment we're dealing with today, tomorrow, and the next day, just trying to stop people getting fired and trying to stop the worst of the behaviour and holding back dam walls. Sorry, Jack, for jumping in.
No, that's I think that's a fair summary. And yes, as I said, this will be recorded, and there is a whole hour or so of what next. But it will very quickly go. The Monash will go to a directions hearing, and we'll get some dates, and we'll keep you in the loop with all of that. There'll no doubt be daily correspondence from us. You can be rest assured we'll be doing everything that we can. So again, thank you, Miles, and thank you today for leading the charge. It's been amazing, and everyone on the call. As I said, appreciate it. Stressful. My heart goes out to you. It really does. It's I can't imagine being in the situation you guys are in. So that we might call time. Thank you very much. Appreciate it. Thanks, Miles.
That's it.
Thanks, Miles.
That's it, bro.